the producer here. We're going to see how this goes. And if this sort of turns off, maybe let me know. This evening, okay, you're on TV.
If you're successful, send me one.
We'll do that. We'll do that.
That'd be great. Well, I wanted to share just a couple of things in mind before, while I was sitting back listening to Randy, before I start on the grand jury presentation. One is an observation that the dramatic difference between the people who inhabited what was later to become the United States of America in 1776 and the people who inhabit America today is there is not an agreement. There's not an agreement as to what the problem is, much less what the solution is. They had an agreement as to what the problem was because they had a unity of understanding of what life was about, what society was supposed to be about, and what government was supposed to be about. And so if you read their writings, you'll find that they have a very similar perspective in that regard. They all came from the same orientation. And it really boils down to what Randy shared last month, whether or not America's a Christian nation. Because the people in the colonies in 1776 were predominantly Christians, they had a similar worldview. They had a similar view of the role of government, the proper role of government, the proper place of government. They had a similar worldview with regard to what was proper conduct in life and in society. And we don't have that today. We don't have unity of worldview across America, even in a majority of the people, with regard to what our government should and should not be, because we don't have people teaching what is the biblical perspective on government and society. We don't have a unity with regard to what is appropriate and inappropriate conduct on the parts of Americans. We don't have a commonality in our morality as they did, more so, much more so than we have today. And so, from my perspective, to change this country, to get it restored, it's going to take the restoration of the people, their personal view, their personal outlook, their personal commitment to morality, to a biblical worldview, before we can look at some major problem and say, what are we going to do to change this? The real revolution will come when, I don't mean taking up arms, I mean the change, the restoration. Revolution means to revolve back to an appropriate thing. And that's what they were doing in 1776. They were revolving back to an appropriate form of government that they believed existed at times in British history. And they believed the king was violating those biblical principles that had been put into the law, the common law of England. And they wanted to revolve it back. They had a revolution to revolve it back to a government that would protect their rights, because they knew that that was the purpose of government. And they knew what their rights were, because they had studied the Bible, and they knew what was right and wrong. They knew when they were being mistreated. They knew when they were being stolen from. And so this country is going to need that kind of a revolution before the whole nation can have a revolution back to what it's supposed to be. So that's just with regard to change and unity. The second thing I'd like to suggest is, before you speak with someone about vocabulary, because that's critical. Vocabulary in our discussion is critical. Study your vocabulary. Get those words. One of the things that I learned early on in trying to understand all this was that there's a difference between government and economics. There's a difference between governmental systems and economic theories. And I came across a high school textbook that said government and economics. And so somebody at some point had also realized that same thing and put it together so that it could be presented to high school students in the form of curriculum. And it was an older book, and I haven't read it. I'm just noting government and economics are two separate things. And so when you talk about things like free enterprise, that's an economic theory. That's not government. There are forms of government like republican, democracy, dictatorship. There are economic systems like free enterprise and communism and socialism. Those are three different economic systems. So you can use a governmental system to implement an economic system or a governmental system to protect an economic system. So make sure you understand that. Additionally, some of the terminology that's used today had a traditional meaning and now it has a modern meaning. Communism used to mean communal living. Everybody shares everything in common. Today we talk about communist Russia. Russia is not a commune. It's a socialist country in terms of economics. And it has a military, basically, dictatorship. And that's their governmental form. But their economic system is socialism. But we call them communists. They are not communists in the traditional sense, but we call them communists. We all talk about communist China, communism in Cuba. None of those places are communal, as everyone understands what a commune would be. And yet we still use those terms today. So be careful when you're using terms that you understand, okay, when I say communist, I mean these guys over in Russia who studied Lenin's writings and Stalin's writings and they believe in that stuff. Okay, well that's a communist under that definition, but they're not a traditional economic communist. So when you're talking about those terms, make sure you get those things straight, or you're going to have some confusion in the room, which will work to the advantage of the people who don't like you, actually. So, I want to share those two things. Third, before I get started, Randy did give me that book, and I just want to say, I hate reading. That is not a passion. It's my wife's passion. She loves reading. She reads books all the time. I could count probably on my two hands the number of books I've read cover to cover in my life. So I'm not a reader. I read of necessity. But I read this book cover to cover because Randy gave it to me. And so I will be trying to touch on what he talks about in his book. But I'm going to address this whole issue of grand jury, probably from a slightly different commencement point. And eventually I'm going to mention something called the Magna Carta. And if you want to see an interesting movie, you get the Russell Crowe version of Robin Hood. And look for references to the Magna Carta in this movie. They're not explicit, but if you're careful, you'll see them. So that's your homework assignment. Get this movie and watch it. You can just watch the very beginning and the very end if you don't like action adventure movies. Just, fast forward through the center for all the ladies who would prefer to have some other form of entertainment. Because it is actually an adventure, there is a little bit of a romance in it, but primarily it's action adventure. But look at the beginning, look at the end, and see if you can find Magna Carta in that movie. Before we begin talking about grand juries, it will be helpful if we discuss the concept of government in general terms. If we look at the word government in a concordance, it will lead us to Isaiah chapter 9, verses 6 and 7. Verse 6, the prophet says, "For unto us a child is born." And in verse 7, it goes on to say, "There will be no end to the increase of his government, to establish and to uphold his kingdom with justice and righteousness from then on." Now that's a prophecy concerning the birth of Christ. That child was born, and it says from then on, there would be no end to the increase of his government. From then on, so we're talking about from Christ's birth forward, his government was going to grow. Now, if we look up that word government in a Hebrew dictionary, we'll find that it means to make like. To make like. Now, if you think about it, that word government, to make like, is a fairly neutral term. We talk about government. So when applied to the context of that verse, it's obviously talking about Christ's efforts to make people Christ-like. Make them like God, make them godly people. And so his government, the purpose of his government is to make people godly people. But in some other setting, like in a modern communist country, the purpose of that government would be to make people like good citizens, good communists. And so the word government is somewhat neutral in that sense. So you have to consider, okay, so what's the purpose of that particular government? What's it trying to make people like? In the Garden of Eden, God placed man there and offered him the opportunity to submit to God as the government over that man's life, so that God would make him and keep him godly. As reflected in Isaiah chapter 33, verse 22, God would be the king, the lawgiver, and the judge. Man's submission to God's government would be entirely voluntary. As an alternative, man could choose to be his own king. He could choose to make his own laws applicable to his life. The problem with choosing to be his own king is that to the extent that any of his actions were violations of God's immutable laws, he would suffer the natural consequences of violating those laws. Additionally, if any of his actions violated the rights of others, then those individuals had the right to punish him as a consequence of violating their rights. But he was given free will, or that opportunity to decide, was God going to rule and reign in his life voluntarily on his part, or was he going to be the king of his own life? Eventually, individuals like Nimrod decided to begin ruling not only over themselves, but over others. Some of the individuals being ruled over by a human king did not rebel because the kingdom afforded them some measure of protection against being attacked by other groups of strong individuals. The size of these kingdoms began to grow over time. Eventually, the ruler of the kingdom was ruling over the entire known world. That's the Babylonian Empire. The ruler over that kingdom, the Babylonian Empire, ruled over the entire world. He was the king. He was the king of himself, and he was the king over all those people. There was a series of 4 such kingdoms over which a tyrannical dictator ruled. These were the kingdoms discussed in Daniel chapter 2. These would be the Babylonian Empire, the Medo-Persian Empire, the Greek Empire, and the Roman Empire. A careful study of Daniel chapter 2 leads to the conclusion that after Christ's coming, the church would have a significant impact on the way a society would be structured, and there would be an ever-increasing growth in the influence of the church over government and society. This is confirmed by the Isaiah passage, where it talks about the increase of Christ's government. Before Christ's coming, there was no such thing as a grand jury. The only thing that existed for century upon century was one tyrannical dictator after another. After Christ's coming, history records different effects that reflect the growing influence of Christianity. By the year 100, Christian missionaries were evangelizing the British Isles and the people who lived there. By the year 380, Christianity had been proclaimed the official religion of the Roman Empire. In 597, the church named the first Archbishop of Canterbury, or the first Archbishop to the British Isles. By the year 900, King Alfred the Great had incorporated the 10 Commandments and other passages from the Bible into the common law of England. By the year 1016, we see one of the first references to a grand jury in the law code of King Ethelred II of England, which included the following explanation or phrase: let 12 elder freemen and their foreman with them retire and swear upon the holy book which is given into their hands that they will not accuse any innocent person nor protect any criminal. From this passage we can see that the grand jury is actually an accusatory organization. It performs an accusatory function. Normally a trial jury will perform a fact-finding function, determining whether or not an accused person is guilty. From this passage from King Ethelred, we can see that the grand jury actually brings criminal charges against someone. By the time of King Richard I, also known as Richard the Lionhearted, during his reign, which lasted from 1189 to 1199, the grand jury consisted of 12 people from every 100 in the kingdom. Richard's younger brother, John, was king when the barons insisted that he sign a document that acknowledged their rights. This document was the Magna Carta, signed in 1215. Numerous writers would look back to the Magna Carta as memorializing the right to a grand jury under the common law. Likely those references were to section 61 of the Magna Carta, where it references the Council of Barons. In that section, if the king or his representatives had violated the Magna Carta, then the violation was to be reported to 4 of the barons. Those barons would investigate the accusation, and if they found it to be true, they would report the accusation to the king. If the king did not correct the problem, then the 4 barons would report the accusation to the full council of 25 barons, and then thereafter those 25 barons were to do everything in their power to force a correction of the problem. Actually, in the Magna Carta, the king signed that document agreeing that if the 25 barons determined that he had done something wrong, they had the right to require every citizen in the kingdom to put pressure on the king in whatever form that took, even to the point of military action. And the king promised that if someone refused, he would punish them. So it's kind of an interesting and very strongly personal rights-oriented document, in that the king signed indicating that if I do something wrong, you need to come after me, and if you don't, I'm going to punish you for not coming after me for doing something wrong. So it sounds like the king was attempting to show his desire to do what was right. Now the king did appeal to the Pope after he signed the Magna Carta. The Pope renounced the Magna Carta and declared it to be null and void within 30 days. The king, within 90 days, repudiated the Magna Carta. However, it didn't become a major deal because the king was passed away within about 6 months, and the heir to the throne was much more amenable to working with the people. And there were a number of Magna Cartas after the first one, but the one in 1215 is the one to which most people referred. Now, I don't agree with authors who say that you would trace the right to a grand jury back to the Magna Carta. Grand juries existed prior to the Magna Carta, as indicated. King Ethelred specifically in his law code referred to that jury of 12 plus their foreman, and that they had an accusatory function, and that's basically one of the major things that a grand jury does. The Magna Carta, the original complaint under the Magna Carta goes to 4 barons. A complaint to the grand jury goes directly to the grand jury, and that would consist of anywhere from 12 to 25 people, depending on your parameters. And in this case, the complaint just went to the 4. They would investigate, and if they found that something wrong had occurred, they would bring the accusatory information to the king. So they were the accusers, the 4. If the king did not correct the problem, then they went to the 25, the 21 plus themselves, and then they would get together, and if they were convinced that something wrong had happened, which would be another investigation, they wouldn't present another accusatory document. they would go and inflict punishment. So they were there to find him guilty and punish him without his involvement. And that's not what the grand jury does. Although the grand jury might find that they're going to accuse someone without their involvement, they would then present that to that person. And I'll go into a little more detail in that regard, with one exception, in just a couple minutes. So I don't think that the Council of 25 Barons is a reference to a grand jury, but there was a grand jury system in place even before 1215. It is part of the common law, and that has been referenced by many writers, including the U.S. Supreme Court, that the grand jury is part of the common law of England. In 1769, that would have been 7 years before the Declaration of Independence, there was a famous legal scholar in Great Britain. His name was William Blackstone, and he wrote a 4-volume encyclopedia of the law. And William Blackstone has been cited by the U.S. Supreme Court many times as an authority on the common law. And his treatise in particular, that 4-volume treatise, as an authoritative on the common law. When he wrote and published Volume 4, that was done in 1769, he included in that a section, because Volume 4 is primarily having to do with crimes and criminal law. Volumes 1, 2, and 3 deal with civil law and society. Volume 4 has to do with criminal law. And so in Section 23, he talks about accusatory activities in the community or in life based on information that someone has done something inappropriate. He, in his Section 23, discussed several modes of prosecution for illegal activity. In this section 23, he also discussed the grand jury. He indicated that the grand jury can attempt to initiate prosecution either using a presentment or an indictment. The term presentment, according to Blackstone, has basically 3 different meanings. It's a very broad term initially, and it also has a meaning that is more narrow. So when you're talking about a presentment in Blackstone, he says they can use a presentment, and a presentment is 1, a presentment, and then 2, I believe the second one was called an inquiry with conviction, and the third one was called an inquiry with an arraignment. So a presentment that is, in fact, simply a presentment is where the grand jury investigates a matter and they simply issue a statement or a report that they believe something that they've observed is wrong. The presentment is sent to the court, and after it's presented to the court, then someone must file an indictment based on that presentment. Not the grand jury, but some other entity, like a prosecutor. They would file an indictment or an information, more likely, once they get the presentment from the grand jury. The second type of presentment is called an inquiry, or an inquisition. Now, the first of the 2 inquisitions, the one with conviction, is where the grand jury investigates petty offenses. And very minor things. However, if the grand jury, in investigating that petty offense, concludes that an offense did occur, nothing further happens by way of trial. The grand jury's conclusion is the final conclusion. So that is the great word here, inquisition with conviction. In that type of inquisition, the grand jury needs to hear from the prosecutor and the accused. In a presentment, they only need to hear from the community or themselves or potentially a prosecutor, and they issue a statement: we think something has occurred, you should consider filing charges. In an inquisition with conviction, they say, we believe something inappropriate has occurred, we believe that you did it, did you want to tell us anything about that? And when the accused person finishes, they say, guilty or not guilty. If they say guilty, then they refer that matter to the sheriff, and the sheriff simply imposes the fine. So the grand jury can actually make findings of guilt. only petty offenses under the common law. This is Blackstone speaking. Only petty offenses, and they need to hear from both sides, because once they're finished, there is no further inquiry. The only question is, if they're guilty, what do they pay? The inquisition with arraignment is where they investigate a matter, and they say, we believe something inappropriate has occurred, and we want you to arraign this person. And so the person goes before the court, and they're before the court. That person gets their first opportunity for input, and they say not guilty or guilty. They put out an indictment. An indictment is very similar to an inquisition with arraignment. They basically do that same investigation. They decide whether they believe that something inappropriate occurred, and if they do, they, under oath, then put the accusation in writing, and that is an indictment. The person must be summoned to court, and they must plead not guilty or guilty to the indictment. So the indictment is a formal document presented under oath by the grand jury, and that's basically the second category of accusations. Now this was Blackstone writing in 1776, and he said this is the common law. And he also quoted King Ethelred in terms of the grand jury and its historical significance, and the fact that it was part of the common law. But he also said that there's other ways to commence prosecutions. You can use the grand jury, but you can also just use a prosecutor. And they would file a document, a charging document called an information. And Blackstone clearly indicated that the filing of an information by a prosecutor is also part of the long history of the common law. And so there's nothing inappropriate about someone deciding that their form of government would include authorizing a prosecutor to go ahead without necessarily having a grand jury indictment. However, at this time, informations could only be for what we call misdemeanors, less serious offenses. Any capital offenses you had to indict by a grand jury. There actually is a third way to commence prosecution in addition to using a grand jury or just a prosecutor using an information. There is something called an appeal. An appeal is an appeal is not the same as what happens when someone goes to court, they don't like the outcome of the court, and they ask a higher court to review that. We call that an appeal, and Blackstone understood that there were those kinds of appeals even in the court system in 1769. But he said there's another way to prosecute someone, and it's called an appeal, and it's actually called a private prosecution. That is where an individual goes to the courthouse, they file criminal charges, and then they prosecute that person for that crime. This was 1769, this was the common law. And he gave details and limitations. It can only be for certain types of crimes. Double jeopardy does attach. So if this person's unsuccessful in prosecuting this person, then the state couldn't say, oh, well, we can do a better job than that. We're convinced that they did it. Now that we've heard about this, we'll go and prosecute them. Couldn't do it because that appeal had been unsuccessful. The person had been found not guilty, and so double jeopardy attaches, and you couldn't try them a second time. So an appeal was a little bit of a tricky thing because it was performed by an individual, one individual. That individual was the prosecutor, and if they were not successful, then that barred any future prosecution of that person. As I said, there are some specific limitations on what we call private prosecution in terms of the types of cases that could be prosecuted. And Blackstone goes into more detail in his treatise. If someone were interested, we're not really talking about an appeal today, we're talking about the grand jury. I'm just saying that the grand jury is one of three ways to commence prosecution of criminal charges. With regard to the grand jury, Blackstone made the following observations. First of all, he said that the sheriff calls the grand jury. Second, the qualifications to serve on a grand jury are that The grand jurors must be good and lawful men of the county, freeholders, and gentlemen of the best figure in the county. So those are the criteria. Good and lawful men, freeholders, gentlemen of the best figure in the county. Now, a freeholder is basically the same as a landowner, but Blackstone said the common law didn't provide for how much land constituted a freeholder. And he also indicated that the legislature would set the parameters for the definition of a freeholder. And so the legislature could establish the criteria, part of the criteria, for serving on a grand jury. A third characteristic is that the grand jury would be limited to inquiring only into matters or offenses which had occurred within their own county. And fourthly, if the grand jury found that the accusation was unsubstantiated, they would issue something called a no true bill, which is just a formal way of responding and saying, okay, we've heard your complaint, it's unfounded, no true bill, nobody has to do anything. If they found the accusation to be substantiated, they would issue a true bill in the form of an indictment. Prior to declaring our independence in 1776, we were British citizens and governed by the common law. There is nothing in any of our constitutional documents subsequent to 1776 that would suggest that we as Americans or we as Floridians have rejected the common law. The Supreme Court continues to acknowledge the requirement that the federal governmental system abide by the common law, except to the extent that it has been appropriately modified by the courts or Congress. In Florida, our legislature has enacted Florida Statute Section 2.01, which provides that the common and statute law of England, which are of a general and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July 1776, are declared to be of force in this state, provided that such statutes in common law are not inconsistent with the Constitution and laws of the United States and the acts of the legislature of the state. So Florida, which was obtained from Spain in 1838, became a state 1845, and they proposed their constitution to Congress before they became a state. Congress approved it, and in 1845, the provision in the Florida Constitution was that the applicability of the common law would be determined by the legislature. So Florida's establishing document, our first constitution, specifically said the legislature can eliminate any or all of the common law. But our current constitution from 1968 has no similar provision. So basically we're back under the common law by virtue of the revisions of our constitution. And our legislature has specifically addressed that we are subject to the common law, except as it's been appropriately modified. So we are under the common law as it relates to grand juries. That's on the Florida level and on the federal level. Now, the question of the grand jury has been addressed by the federal level by the U.S. Supreme Court on a number of different occasions. On one of those occasions, and it was a case that was, I believe, from the 90s, United States versus Williams, the majority of the Supreme Court made the following observations with regard to the federal grand jury. Now, we do have two different governmental systems here in the United States. We have our federal government and our state government. And so we have two different grand jury systems, the federal grand jury system and the state grand jury system. Here in Florida, by legislative enactment, we have two grand jury systems here in Florida, that being the statewide grand jury and the county grand jury. And I'll go into that in just a little more detail in just a little bit. But with regard to the federal grand jury system, the court in the case cited indicated, one, because the grand jury was not textually assigned in the U.S. Constitution to any of the branches of government described in the first three articles, it is a constitutional figure in its own right. So what that means is that we did not reject the common law when we became the United States of America in 1776. We did not reject the common law when we established our form of government in the Constitution that was developed in 1787, ratified by 1788. And we didn't, in that Constitution that was ratified in 1788, address where the grand jury would fall in our society. And so it falls outside the Constitution. In the Fifth Amendment, in the Bill of Rights, it mentions that you cannot prosecute for a capital crime without indictment by a grand jury. So clearly there was an acknowledgement in 1787 that the grand jury still existed and would continue, but they didn't put it under the legislative branch, they didn't put it under the executive branch, they didn't put it under the judicial branch. So today, the common law grand jury at the federal level is not under any of the three branches of government. It is textually separate. And so it is a constitutional figure in its own right. Two, the grand jury is an institution separate from the courts, over whose functioning the courts do not preside. Courts exercise no supervisory judicial authority. And in this particular case, the Williams case, one of the courts, lower courts, had passed a regulation for the grand juries that indicated that the prosecutors had to make full disclosure to the grand jury. If a prosecutor goes to the grand jury and says, we want you to indict this guy for mortgage fraud, if the prosecutor knew that there was some indication that he had committed mortgage fraud, but there was some indication that he hadn't, the strictures of the lower court said the prosecutor has to disclose both pieces of information. The Supreme Court said no. The courts don't supervise the grand jury. The grand jury can take information or they can not take information. It's up to them. So you can't insist they be given information that they don't have to take, because the courts don't supervise the work of the grand jury. Now they do, in many places, constitute or call the grand jury, but they don't supervise their work. The grand jury function, belonging to no branch of the institutional government, this is point 3, acts as a kind of buffer or referee between the government and the people. So this is where, if the government has passed laws, or if a prosecutor develops a certain set of facts and wants to present those to a grand jury for indictment, the grand jury can actually say, we don't like that law. We're not going to enforce that law. Or we don't like these facts. We know that technically these facts might match this law, but in this particular case, it would be an injustice to prosecute this person under this law. And so the grand jury can reject the law, or they can reject the facts. That's their buffer role between the government being oppressive and the people. Point 5, unlike the court, whose jurisdiction is predicated upon a specific case or controversy. So if somebody brings a case to the court, that's all the court can consider. The court can't just on its own say, listen, I heard something the other day. I want somebody to go out and check and see if this is true. The court can't do that. The grand jury can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. So once the grand jury is convened, they can investigate whatever they believe is appropriate to fulfill their function as making sure that the county is being operated with justice. And so if the prosecutor doesn't bring something to them that they want to look into, they can investigate whatever matter they feel is appropriate. This is what the federal court, the U.S. Supreme Court, said about the federal grand jury system. Number 6, the grand jury requires no authorization from its constituting court to initiate an investigation. In its day-to-day functioning, the grand jury generally operates without the interference of a presiding judge. The grand jury swears its own witnesses and deliberates in total secrecy. Number 7, the grand jury cannot compel the appearance of witnesses and the production of evidence. They must appeal to the court to have that done, and the court can refuse to subpoena witnesses where they believe the work of the grand jury would violate someone's rights. Otherwise, the courts are required to cooperate with and assist the grand jury by issuing subpoenas. An example of where a judge might say, well, you want this lady subpoenaed to testify, but she's going to be testifying against her husband. You're going to be asking her to disclose basically the information that he told her, and there's, in the law, a marital privilege. And so we're not going to allow you to violate their right under the law, so we're not going to subpoena her. So a court could refuse a subpoena where the grand jury was going overboard and violating people's rights. If a grand jury said, we want to insist that someone come in here because we suspect them of a crime, we want them to testify against themselves. Well, they have the Fifth Amendment privilege against self-incrimination. And so if they didn't want to come in and testify, they didn't have to. So the court may refuse a subpoena where they believe that the grand jury is going to violate someone's rights. Otherwise, though, the court can't say, well, I don't see how that relates to your case. I don't see how that relates to your investigation. I don't think that's relevant. I think that's going to produce hearsay. Doesn't matter. The courts cannot supervise the kind of evidence that the grand jury considers, except if the grand jury is going basically out of bounds and violating people's rights. Number 8, certain constitutional protections afforded to defendants in criminal proceedings have no applicability before the grand jury. So, as I mentioned, they do have the privilege against self-incrimination, but they do not have a privilege against double jeopardy if one grand jury investigates a case, issues a no true bill, the next grand jury investigates the same case, and issues a true bill. There is no violation of the double jeopardy clause. If that happens, it does not apply to a grand jury. Another right that doesn't apply is the right to counsel. If someone is brought before the grand jury, they don't have the right to have court-appointed attorneys, because that doesn't apply to the grand jury setting. Another thing that does not apply is the right to have illegally obtained evidence suppressed. If someone is under arrest and the officer is supposed to read them their Miranda rights, and the officer doesn't read them their Miranda rights, and they make a statement, and then the officer chronicles that, and later on, that person, though not charged based on that information is later given to the grand jury. Normally, in a court of law, that would be suppressed. And so the finder of fact, which would be what we call a petit jury, small jury, the 12-person jury, they wouldn't be able to hear that information that was contained in violation of Miranda. That doesn't apply in front of a grand jury. Another thing that doesn't apply is the hearsay rule. In court, if you want the jury to hear something, you have to bring the witness. The witness has to testify in person. You can't bring somebody in who heard the person say something and say, well, I heard you say the light was green. No, you have to bring the person in who said the light was green, and they have to testify to the petit jury. That doesn't apply in front of a grand jury. You can bring someone in and they can say, well, I heard the guy say the light was green. And that's perfectly acceptable. No one can undermine an indictment by a grand jury by saying, well, yeah, but they were listening to hearsay. It doesn't apply. So the grand jury has a lot more latitude evidentiarily than the petit jury or the courts. So they have a broader, they have more leeway. That's the federal grand jury system. The Florida system is set up under Chapter, I believe it's 905, and the Florida legislature has basically put in most of what Blackstone and the federal courts do with regard to our jury. In Florida, what I call the county grand juries are called by the chief judge. We have 20 circuits here in the state of Florida. Right now we're in what's called the 12th Circuit. The 12th Circuit includes Sarasota, Manatee, and DeSoto counties. Just to the east and south is the 20th Circuit: Charlotte, Lee, Collier, Glades, and Henry. The 12th Circuit has a chief judge, Judge Williams. The 20th Circuit has a chief judge, Judge McHugh. Each of those chief judges is tasked with calling the grand jury for their circuit, and they call them on a county-by-county basis. The chief judge is supposed to call a grand jury regularly. The chief judge can also call a grand jury at the request of someone. They can call them at the request of a prosecutor, but they could call a grand jury at the request of a citizen. And And so, but the chief judge is supposed to be calling the grand jury regularly. Once the grand jury convenes, their proceedings are secret. The names of the people who serve on the grand jury are secret, with the exception of the foreman, because the foreman has to sign presentment or an indictment, anything that comes out of the grand jury. So the identity of the foreman is going to be known, but the other members are unknown. And the grand jury deliberates in secret. The grand jury can require that no one be in the room but them. They can allow the prosecutor to come into the room and present a case. They can have witnesses brought into the room. Those would be the only people who would know the content or the makeup of grand jury, would be the prosecutor, if they're invited in, and witnesses. And then what they decide to do is up to them. They can issue no true bills, they can issue a presentment, or they can issue an indictment. And it's entirely up to them. They can investigate what the prosecutor wants them to investigate, or they can investigate, as Blackstone said, something that comes to their attention. And so that's the local grand jury system. We have a statewide grand jury that is called by the governor, and the governor would ask the chief judge of the Florida Supreme Court to summons a statewide grand jury. The strictures of the grand jury under the common law, limiting the grand jury to investigating when they're a county grand jury, only matters that occur in their county, does apply generally. But if the chief judge believes that for whatever reason, whatever dynamics are going on, that local grand jury will not be able to adequately investigate a matter, the chief judge can assign that investigation to occur in another county, or even in another circuit. But it would happen in another county, in another circuit. So the chief judge can select where that grand jury would serve, and in that sense, they would investigate only what had occurred in the one county. So the venue for any grand jury investigation on the county level is that county. The statewide grand jury would investigate matters that would cross county and circuit borders, and so they would tend to have the larger, more organized criminal activity that they would investigate and issue an indictment if they choose to, or no true bill if they find that the accusations are unsubstantiated. And so that's the way the grand jury system works here in Florida and on the federal level. I know an individual who was served on a grand jury, and she did disclose that she served on a grand jury. And there is some implication in the Williams case from the U.S. Supreme Court that the secrecy of the grand jury is appropriate, but to the extent that it would violate a person's right to free speech, and there's no countervailing policy that would require secrecy, it might be a violation of the right to free speech to say no person on a grand jury can ever talk about their service on a grand jury. The reasons why the grand jury's proceedings are secret is generally there are two major reasons. The first would be that it's, as with any prosecution, it's sometimes important that the person who's the object of the investigation not know that they are the object of a criminal investigation, because that would tend to cause them to either put their guard up or plead the jurisdiction. So they're secret so that that type of information doesn't get out. And they're also secret so that there is no possibility of juror influence, someone influencing a grand juror through intimidation, bribery, or any other type of inappropriate conduct. So their participation is kept secret. However, there are some things that would be countervailing to that, such as if a wife is serving on a grand jury and she has to tell her husband, well, I have to go down to Fort Myers this week, every day, for 8 hours, I'll be back at dinner time. And the husband says, where are you going, dear? She says, well, I realize that we're both retired, but I'm just going down to Fort Myers. But why? I can't tell you. Oh, are you having an affair? Well, I can't tell you. Because if I told you no, you keep asking until you got the right question, and then you know, or I have to say I can't tell you, and that you would know by that what I'm doing. so I can't tell you yes or no about anything. Well, that certainly would be difficult and straining on that relationship. And so my wife did disclose to me that she was serving on a grand jury and that she would be gone 1 week a month for about a 9-month period. Oh, okay, I understand now. And so you can see where that total secrecy can't be completely required, but it must be honored. Once you've finished your grand jury service and the person has been indicted, then those dynamics of non-influence of jurors and flight of the defendant are no longer come to play. And so unless there's some other reason why your proceedings should be secret, is probable based on the Williams case. And if you want to test it and be held in contempt and go to jail and have your case taken up to the U.S. Supreme Court, knock yourself out, you'd probably win after a long and difficult battle, but you probably would win because it would be a violation of your right to free speech to say you can't talk about something when there's really no reason for you to not talk about it, just because someone wants it to be secret. That's a violation of our right to free speech. And that's basically arbitrary tyranny when someone says, I don't want you to do something just because I don't want you to do it. Kind of like making people stop at stop signs. There's a useful purpose in stop signs at every intersection, but every intersection where there's a stop sign, you have to stop or you can get a ticket. So that's arbitrary tyranny. That's an example of that. And so that would be the theory or the legal analysis of someone being required to not disclose ever their involvement in a grand jury, and I think the Williams case supports that. So that, I believe, is the information that I have with regard to the grand jury system as it exists here in Florida and the U.S. In that we have those 2 levels, federal grand jury, state grand jury, 2 state grand juries, statewide and county, and those function pursuant to the Florida statutes. As I mentioned, both Blackstone and in the Williams case, that opinion also mentions that some of the parameters of the grand jury's activities are going to have to be set by the legislature. Like, as Blackstone said, what constitutes a freeholder? The legislature set that, Parliament, back in that day. Today, our legislature does set some of the parameters with regard to the grand jury activity, but they cannot set parameters in certain areas. And if you review our grand jury statute, if you have the time, you'll find that there is an effort on the part of our legislature to place very few limitations on our grand jury. If you read the language carefully, you'll see that they can investigate something that's brought to them by the prosecutor or other matters that come to their attention. That kind of language. So it's, from my perspective, a fairly good statute on grand juries. Okay?
Well, I have a question.
Okay.
We've had some situations where people have wanted to contact the grand jury and lay out something before them to investigate, but haven't sometimes been successful in even finding out who the chairman of the grand jury is or how to present something to the grand jury. So how would you suggest someone present something to the grand jury?
If you know that the grand jury is in session, and that isn't always known not because there's a concerted effort to hide it from the public, but there's a concerted effort to maintain that secrecy, and that secrecy is from people who are being investigated knowing about the investigation, but it results in the public frequently not knowing that there's a grand jury in session. But if you know that the grand jury is in session, then you should be able to contact the clerk and ask that a letter be delivered to the chairman of the grand jury. Now, in the book, Consent of the Governed, he suggests something very much like that. And, that should result in the foreman being contacted. And if you say, I believe that there's something inappropriate going on, I think you should investigate it, you should be able to tell the foreman that, and they should be able to investigate it. Now, in discussing this whole concept, you'll find that the idea of the grand jury acting in accordance with its legitimate scope is a bit of a scary concept to those in government. One, it's new. Unless you've read a book like Consent of the Governed, you probably don't realize the breadth of the work that the grand jury can do. I mean, that if they're called, like the chief judge calls a grand jury, and the prosecutor said, I want to present some information to you because I want you to indict somebody, the grand jury can say, no, we're busy. We don't want to hear you right now. I mean, that would be a lawful position. The grand jury does not have to hear from the prosecutor. A lot of people call the grand jury the prosecutorial rubber stamp. Well, that's just because of the common use of the grand jury by the prosecutors to obtain an indictment. And an indictment is based on what's called probable cause. The prosecutor doesn't have to present any exculpatory information of anything that would suggest the person's not guilty. The prosecutor can present just information that would suggest the person is guilty. That's lawful, that's appropriate, it's perfectly appropriate out of the Williams case. So you can see where a grand jury, if they're listening to the prosecutor, might tend to indict many more times than not based on the prosecutor's request. And there aren't a lot of other people who try to approach the grand jury. So as a matter of common practice, people have habitually learned that the purpose of the grand jury is so the prosecutor can get an indictment. And that's the common belief. Although it's very clear from reading the U.S. versus Williams case, doing the research on this, the historical purpose of the grand jury is much, much broader and is still alive and well today. There is nothing that would suggest that it's been diminished. It's just that through lack of use, lack of familiarity, people aren't aware of what they can do. If the clerk refuses to deliver your letter, then you might want to contact an attorney, because you might actually have to take legal steps to require the clerk to deliver the letter.
So you have to go through the clerk. You wouldn't know who the grand jury chairman is by name?
You should be able to know who the grand jury chairman's name is by inquiring once again of the clerk. If the clerk doesn't tell you, you go to the prosecutor's office and ask them, who is the chairman of the grand jury? They may say, oh, I can't tell you, it's secret. And then you can say, well, wait, I understand that all the other members of the grand jury's names are secret, but the chairman's not secret. If you get an indictment from them, you're going to have him sign that. So it's not secret. So under the law, you can disclose that. And if he still won't tell you, then you would have to go to the chief judge, because the chief judge impaneled or called the grand jury. And you can ask the chief judge, well, who was selected as the foreman of the grand jury? And if the chief judge won't tell you, I can't tell you, it's secret. You have to do some education. If education doesn't work, then your only recourse is you have to go hire an attorney. And that attorney has to take they know the words for explaining what you do in the courts, but they would have to file something to get a court order insisting that the clerk disclose that information. And then if the trial judge says, no, I'm not going to order the clerk to disclose that, it's secret, and your attorney gives them all the case law and all the legal precedent, and the judge rules against you, you have to be prepared to appeal the case to an appellate court. And if they deny it here in Florida, Florida Supreme Court won't accept search for area, or they deny it, you have to go to the federal system, and eventually you have to go to the Supreme Court, where you should be able to cite their precedent and get them to say that's a violation of your rights as a citizen, for them to refuse to issue we call writ of mandamus, requiring the clerk to disclose this information. So it could take some expensive, hard work. But to me, the first step is education. Like what you all are doing here. You probably, unless you've read that book, know now that the grand jury, if you, for some reason, heard who the foreman was, and you saw him at Denny's, you could say, hey, listen, can I give you a piece of paper here that lists some information that you guys really should look into. He takes it, he reads it, takes it to the grand jury. They can investigate that. They can issue subpoenas. It doesn't have to come from the prosecutor. It can come from any source, and the grand jury can investigate anything. And you may recall that phrase that I read to you. See if I can put my hands back on it. Unlike the court, whose jurisdiction is predicated upon a specific case or controversy, the grand jury can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. So the prosecutor isn't going to bring a case in and say, well, we don't think the law is being violated, but we think you should investigate this. The prosecutor's not going to waste their time, but the grand jury can spend their time investigating in that manner. And they can investigate the things that were mentioned in that book. They can say, well, we want to check the financial audit for the county. Send us the audit. Somebody audits the county's books, and so they could have that audit presented to them, and they could review it. And if they know a CPA, they could subpoena the CPA as a witness, have the CPA take a look at it and tell them what all those numbers mean, and they could see if the county is functioning lawfully and disposing of their tax revenue appropriately. They could look into that. They could look into any aspect of the function of government that they care to, because they have that authority. And that's U.S. versus Williams. One of those points, I mentioned there are 8 points. One of them, number 5 on my list, they can investigate merely on suspicion that the law is being violated, or even because they want to assure themselves that the law is not being violated. So that's the scope of the power of the grand jury. Yes, ma'am?
In reality, how many cases do you think, or would we have any way of knowing that the grand jury takes from citizens versus prosecutors? It sounds like prosecutors can tap into the system very easily, and it sounds to me like citizens cannot tap into it easily, even to find out who to go to, and they have to be able to finance that, which is prohibitive for a lot of citizens.
Correct. That is correct. And part of the problem is, as I mentioned, the habitual non-use of the grand jury over the recent history over the last 100 years. That habitual non-use has resulted in people believing that the grand jury can't be used for those things. It's like if you go to the public school system. Great people in the public school system doing the best that they can under the constraints that they have. But they will not be teaching the reality of God or the work of Christ in redeeming mankind. They're not going to teach that. And so what do the kids hear for 8 hours every day with regard to the reality of God and the work of Christ on the cross? Silence. So it's like God's not there. It's not real. And so through that habitual non-discussion of that issue, or an affirmative avoidance of that issue, the textbooks will not attribute acts in American history to miraculous intervention by God. They won't, because they think they'll get in trouble, or they're part of an effort to undermine that aspect of our society. And so that's an illustration of what has happened in the grand jury system. Habitual non-use results in a belief that it can't be used. And so that's where we are today. Ma'am?
My question is this: if ordinary citizens are called upon to serve on a grand jury, unless you're there to tell them what their scope of responsibility is, how would they know? Are they told that by the judge that calls them?
There is a federal grand jury handbook, and there is a Florida grand jury handbook. There's also a federal grand jury guide and a Florida grand jury guide. The guides are prepared by attorneys or non-Supreme Court people, the handbooks are actually prepared by the court. And so the handbook is more specific. But if the grand jurors are given those handbooks, then that can serve to help educate them. If you read this book, Consent of the Governed, you'll see that the experience of the gentleman in Dixie County was, he wasn't given anything. So it depends on what the grand jury is given.
That would that would explain why there are problems, because if you did see the foreman and then you did ask him if he could take this letter that explains certain things, he may not know he's permitted to do that.
Right, right. And so, if you had a copy of the Florida Grand Jury Handbook, right, now, there's kind of a weird thing out there, and I can't explain it, and I have no conspiracy theory with regard to it, but the Florida Supreme Court has developed a grand jury handbook. There's a research tool called Westlaw, and Westlaw lists all the Florida statutes and all our rules of procedure, civil and criminal, and it lists the statute on grand juries, and it lists jury instructions for pettit juries. And the last thing that it lists under the jury instructions is Jury Instruction Handbook. And after it, in parentheses, it says, omitted. Now this is a private company, Westlaw, so they're not an arm of the government. So I don't know why the grand jury handbook has been omitted, but I got an outdated copy of the grand jury handbook where the Florida Supreme Court just made some clerical modifications. And so my copy has the old text with X's through it, and the new text with lines under it, and then everything else has no markings at all. So you kind of have to put up with that as you're reading it, but it's not a clear copy, and I had to kind of get that off another research that I did through another route, but it's not on Westlaw, so you're going to have to find a way to get that copy. Yes, sir.
What do citizens of this country do when they have uncovered a scenario or a crime at the highest levels of government, such as the federal and the state? For example, there are thousands of architects and engineers in the United States that have formed an organization. There are over 2,400 licensed architects and engineers who design, maintain, and construct buildings. They have stated that 9/11 did not happen. The buildings did not fall due to the planes hitting them and jet fuel, etc., etc. These are the very men that design, build them, and maintain them. So obviously their testimony is very weighty. What does the people do when the federal government is not willing to investigate these merited claims? What does the people do when their own state of, for example, New York, the governor, the prosecutor will not investigate these merited claims by licensed professionals, numbering in the thousands? What does the people do in such a scenario when your state and federal government will not listen to you nor obey your requests?
You're going to find that there would be two grand juries that would have jurisdiction over that issue. The first would be the federal grand jury for the district in which those buildings were located, and then the state grand jury for the county in which those buildings were located, which I don't know the name of that county that Manhattan's located in. I'm not familiar. Nassau County located. And so they got, New York City has more than one county that it encompasses, so you'd have to find the right county. And then you'd have to do what I was saying, is you'd have to find the name of the chairman of the federal grand jury or the name of the chairman of the county grand jury.
It's been attempted and it's being denied.
Then you have to go that next step.
That too has been attempted and denied.
Okay, so you take it to the courts, both the state and the federal, and then you have to appeal it. And once you lose on appeal, you have to be prepared to appeal it to the next level, and then come over into the federal system, and you eventually would have to ask the U.S. Supreme Court to declare that it's a violation of your right as a citizen to be denied access to the grand jury, because that's the whole purpose for the grand jury functioning, is to allow them to be that buffer between the government and the people. And it's not just a buffer against prosecution, it is a buffer against an inappropriate government. When the king signed the Magna Carta, he didn't say, if I have only oppressed you. Basically, he said, if I've done something that violates this document. Now, that's not a direct quote of the document. You have to look at it a little more carefully. But basically, the investigation of the king's conduct is supposed to take place if the people want to assure themselves that no crime has been committed. I mean, that was that U.S. Supreme Court, U.S. versus Williams. If that grand jury wanted to, they should be able to. And if no one can have access to them, to give them the information so that they might even suspect that they need to do an investigation, then there's got to be some remedy. And the U.S. Supreme Court would have to tell those lower courts, hey, give them access, because you're denying their rights as Americans to access to the fourth branch of government. Yes, sir.
Me?
Yes, sir.
What if Charlotte County Sheriff Bill PRUMMELL and the courts both have denied the existence of grand jury, will not recognize it, etc.? What do you do for that?
Well, we don't have a grand jury sitting right now, as far as I know, and I have fairly current information on that. And so here we are, April 12th, and 2016. There isn't a grand jury sitting here in Charlotte County. So the next grand jury is going to be summoned by the chief judge in Charlotte County, based on some request. So you have to find out from the chief judge whether or not he's summoned a grand jury. So that's where you have to check. That's down in Lee County.
You don't have to have a grand jury all the time.
Okay, good question. The statute says that the chief judge should summon a grand jury regularly. That's what the statute says. And the grand jury's term is 6 months. So whatever regular means, which I would suggest it might mean repetitively, there should be one on a regular basis. And I think that, once again, through habitual non-use, we don't have grand juries sitting regularly because the prosecutor hasn't said anything, the people haven't said we want a grand jury, even though the prosecutor doesn't need one right now. We'd really like one just to investigate the county and make sure that we're up to snuff. Through habitual non-use, we don't have a regular grand jury.
If I read correctly, in the state of Florida, a prosecutor doesn't have to go before a grand jury unless there is a capital offense with possibility of death penalty. So
that is true for the federal prosecutor. I have to check to see if it's true for the state prosecutor, because our Constitution is more generous to our prosecutors than the federal Constitution. The Fifth Amendment is very limiting in terms of capital crimes.
Well, I have something I'd like for us to do, because I don't think we have experimented with this. Quite a few of you are going to leave before our next meeting. So here's what I'd like for us to try to do, is those of us who are in Charlotte County, maybe pick a representative. Those in Sarasota County, pick somebody here. And whenever you go back to your counties up north, have as your goal this next month to try to find out the name of the foreman of a grand jury in your county. And then see if we can do that. Yes, ma'am?
I have a couple of questions. One,
Yes, ma'am.
is the common law grand jury in a court of record the same thing as the grand jury that you're talking about?
No, it's not. You're referring to statutory.
Excuse me, Mr. Crook. Yeah, let me answer the question. The common law established a grand jury, and the common law allows the legislature to set some parameters with regard to calling the grand jury. And at this time, the federal grand jury is called by the court, and the state grand jury is called by the court. And so there isn't any existing mechanism for anything else, because those provisions have been put in place. If we want to argue, well, wait a minute, we should have an independent right to our own grand jury, you won't find that necessarily in the common law. However, you can change the limitations on the current grand jury, but there isn't a provision that would allow 12 of us as private citizens to get together and say, let's be a grand jury, or let's call a grand jury, and let's pick these people, because under Blackstone, the sheriff called the grand jury. People couldn't just say, we want a grand jury. There's got to be a people's grand jury or a common law grand jury. Blackstone is the man on the common law. He's got 4 volumes, and in those commentaries he says the grand jury is called by the sheriff. Now, we have modified that by legislature and said, okay, well, we're not going to have the sheriff call the grand jury, we're going to have the chief judge call the grand jury. But that's all they do, is they call the grand jury. The sheriff doesn't supervise the grand jury, the chief judge didn't supervise the grand jury, the chief judge doesn't supervise the grand jury. But under our current system, it appears from my research that there isn't a third alternative from the federal and the state.
And the other question is, there's a judge in Anna Maria Reitzinger who wrote probable affidavit. I suggest that everybody read it. It's really good. But in there, she makes the accusation that our government, and especially the Bar Association, is not necessarily upholding the law. So people are kind of bumping their heads, and they're not getting the justice that affords not the citizens. You don't want to be a U.S. citizen. You want to be a land jurisdiction, and not one who is in admiralty or administrative law, because you're not going to get justice there. They are corporations. It's interesting. If you think that book is interesting, that book is even better. It's Anna Maria Reitzinger.
And
You know something is wrong when ...
Okay.
It's available at Amazon, and that will make a better. That will give you what's happening in our country today, and why we have all the problems we do.
The name of the book is, again?
It's Anna Maria Reitzinger, Reitzinger, and it's just a picture of the whistlers. You know, it's about this big. It's very easy to read, but she has brought an affidavit against everyone in government, police force, you name it, and she makes a really good
argument. I think the implication is there aren't a lot of authors named Anna Marie.
Anna Maria Reitzinger, Reitz.
Google that, you should find it.
Yeah.
Mr. Kessler.
When I've been called in for jury duty, usually there's a bunch of lawyers around that pick and choose who's going to be on the jury, and they don't like you, you're not on the jury. Is that the same as a grand jury? Do they come in and you say they don't they don't run it. If judge doesn't run it and nobody runs it, but how are they saying that I don't like that person and I like that person? How are they not controlling it if they're doing that?
Yeah, that's a very good question, because in our Florida statutes on the grand jury, it says that the same rules apply for disqualifying jurors as applied to the pettit juries. Now, the Florida Supreme Court is the one that says those lawyers can pick three and ask them to go for no reason. It's called a peremptory challenge. That doesn't apply before the grand jury. But the implication is that if a juror is disqualified, they can be required to not serve. But I have not investigated, so I'm not familiar with that portion of the process where they would sort out who's going to serve, who handles that aspect of the calling.
Do they call an excess and knock some people off when they call a jury, a grand jury?
They would call an excess because some people don't show up, and they need to get down to, I think, 21. No less than 15, no more than 21. So they would, if some people, more than 21 show up, they would let some go. And they don't know how many are going to show up. And they don't just call 21 and then go find those people when they don't show up. We don't, it's just not the way we conduct it, so they could call an excess.
You can be excused in the same way.
That is correct. You can ask for an excusal under the same rules as you can be excused. So if you are, I guess, a pregnant mom or a nursing mother or over the age of something, 70 probably, you can be excused from grand jury service, the same as pettit jury service. But I really don't know that sorting mechanism in terms of someone objecting to somebody because they're not qualified. If other jurors would have to do that, or the prosecutor or the judge, I don't have that answer.
Have any of you ever served on a grand jury? Locally?
No, in New Jersey, many years ago, but the judge is saying, it's starting to come back to me, yeah, and that happens. But I'll tell you this much, my experience was that the prosecutor really drove the whole process, or we tried to. But I was the foreman, by the way, and we knew Bill the cases that he wanted prosecuted. So we weren't, I wasn't a stable person.
And that's okay.
And he later became a Superior Court judge.
It's really okay. The grand jury shouldn't be the prosecutor's favorite person. Unfortunately, just by way of human nature, many people like to be liked. I'm one of those. And so if I'm in a grand jury room and I was selected to be on a grand jury, and the prosecutor comes in and it's just him and us, and we're talking, I'm going to be smiling and I'm going to be interacting in a positive way. I'm not going to be sitting there saying, what are you doing? What are you doing that for? Why do you, I'm not going to be that. Now, some people may have that personality and they don't have a problem with being confrontational, but I think human nature is more we either don't do anything or we're actually overly cooperative. And that's, once again, one of the reasons why the grand jury is just seen as a tool of the prosecution. It's because they go in there and say, this is the case. And if you read this Williams case and you read the book, you'll see where some people have been told by the prosecutor, no, you can't do this and you can't do, and they were overstepping their bounds. But the jury doesn't know because they haven't been educated. They don't have that handbook. They don't have that training. And I told you there's a handbook and a guide. The guide was written by the Florida Bar. So it's the attorneys in the Florida Bar that wrote the guide. I read the guide. It's not atrocious. It does concede some of the points that you can see in Williams, that the grand jury can investigate what the prosecutor says and anything else. It concede those points, but it's not designed to be encouraging of the independence of the grand jury.
Let's take the last question. If you have questions, and we'll...
Yes, sir.
Thanks for sharing your knowledge and coming out and speaking with us. And so the book Consent of the Governed, do you feel it's accurate and that is, the information given there to, follow those procedures to start a grand jury and, so forth?
Well, I did, hold on just a second. My big question when I first started hearing about this issue and this question was, okay, we want this independent grand jury and we know it's part of American history and the common law, but who calls the grand jury? Who calls the grand jury? And this book talks about the federal and the state and the common law grand jury. And so I looked under his question 5, page 199, who calls the grand jury together? Similar to the other question, this one should be reworded, who should call a grand jury together? My first observation when answering the question suggests that there's so much corruption and unconstitutional activity in government today, there wouldn't be a need to call a grand jury together because it should be meeting all the time or at least on a regular basis. Well, he's right there. Statutorily, it should be meeting on a regular basis. With that said, though, and given the Fifth Amendment listing of 2 instances where a person can be held to answer for a crime on a presentment or information, the grand jury can be called together either by members of the grand jury themselves, by their own initiative, or by a prosecutor. This man's from Florida. Now, he's commenting on the Florida and the federal, but that's wrong. Okay? The grand jury can't call itself. There isn't a standing grand jury. There aren't 15 to 21 people living in Sarasota County who know that they're on the grand jury. Somehow they just know in their heart, and they're always on the grand jury. They can call themselves together at any time. No. The Florida statute clearly indicates the term of the grand jury is 6 months. That can be extended by 3 months upon petitioning the court, and the court can grant a 3-month extension of the grand jury so they can extend their investigation if they need to. At the end of the term, their service expires. So my wife is no longer on the grand jury here in Fort Myers. You're no longer on the grand jury in New Jersey. So his statement is not accurate. That is not how you call a grand jury. They can't call themselves. And the prosecutor doesn't call the grand jury. The prosecutor goes to the chief judge and asks the chief judge to summon the grand jury, and the chief judge directs the clerk to issue the summonses that go out to call the grand jury. So there is some inaccurate information. Additionally, he does not distinguish between the 3 types that he's talking about, federal, state, and the common law grand jury, when he's talking about remedies and what you should do. And in his back section, he says, well, here's a listing of things that you could have your grand jury investigate. And he makes a list, but he doesn't distinguish. He doesn't say, this should be done by the federal grand jury, this should be done by your state, county grand jury, the statewide prosecutor, your common law grand jury, because he talks about that common law grand jury, but he doesn't talk about how you constitute that common law grand jury. He did nowhere in all his research, and he was researching Florida in addition to federal, nowhere does he say this is how you constitute a Florida citizen grand jury. And I couldn't find it anywhere because historically it doesn't exist. Historically, our legislature has modified the common law provision that says the sheriff calls the grand jury and put the chief judge calls the grand jury. But even if that were not constitutional, the sheriff calls the grand jury. We don't call the grand jury, individuals don't call the grand jury, the grand jury doesn't call the grand jury, the prosecutor doesn't call the grand jury. Under the common law, the sheriff would. Under our current statutes, the chief judge. This man is very passionate. He's very concerned. He did some very thorough research. He's got some good citations to authority. I recommend that if you read this book, you investigate what I call original sources, which would be the Magna Carta itself, Blackstone. All you have to get is volume. You can go online. You can go online and you can get Blackstone's commentaries on the common law. You can search them by volume. You can search them by section. Volume 4, section 23. And you can print just that section. And it's not that long. Okay, so that's, if you're going to read this book, then I recommend that you get to original sources, and that will help you. And you can do some of this research yourself online. But in terms of a guidebook, it leaves a little to be desired. But I appreciate his passion. He is definitely a passionate man. He definitely sees a problem. But this is all part of what I said at the very beginning. We're not going to have a solution to the problems in this country until we get unity in our worldview, which happens down at a local level. Until everyone agrees what is moral, what is right, what is the proper role of government, that the Bible should guide us in all of that. And that was the position of the founders. That is why they were able to advance their cause. They came over here for religious freedom. 1740s, there was the First Great Awakening. tremendous resurgence in Christianity to the extent that it might have waned any since the early 1600s when they started settling the area. Tremendous influence of Christianity and biblical thinking on the founders and on the common law. I mentioned to you King Alfred the Great, 899, put the Ten Commandments into the common law of England. That was the influence of Christianity on the political philosophy and the governmental philosophy of Great Britain and the British descendants, of whom we are. Until we gain that re-recognition that that's our history, that's our orientation, that's what the founders put in place, and that will tell us what our problems are, we're all going to be disjointed in terms of saying, well, this is what the problem is, this is what's important, this is the solution, that's the solution. And basically the people who are trying to change in a negative direction, who are unified, are going to basically roll over us. It's another question.
Just one
Wait a
last
minute.
question.
Mr. Krug has his hand raised first, then this.
Yes. One of the things I want to share with everybody is, you know, the battle we fight is not against flesh and blood. It's not against judge, it's not against the government. It's against the spirit behind it all. One of the things that we need to do is change the way we think. All right? One of the things people need is to know the solution. The solution is our representatives, who one is standing right there. He took an oath to uphold and defend the Constitution, which was put in place to protect the inalienable rights given to us by our Creator. People who are in office need to be held to that oath. If that is done, the battle has been won.
All right, Judge, thank you
Very much.
All right, one last question, very relevant. If citizens of Charlotte County uncover and detect criminal activity by the government, how do the citizens engage the grand jury to get their audience, to get their ear, and have an evaluation of the evidence by citizens in Charlotte County? How is that done lawfully?
I would recommend, as a practical matter, get your evidence very thoroughly put together, just so that you are intimately familiar with it to the fullest extent practical. I'm not saying memorize it, but I'm saying make sure that you've got your information fairly well put together, because your next step is going to be to go to the chief judge and say, Your Honor, I have information that there's criminal activity in Charlotte County, Florida. I would like it investigated by a grand jury. Would you please summons a grand jury? And if you can give the chief judge maybe a brief, you don't have to justify the calling of a grand jury. They should be done, as I said, on a regular basis. But if you can give the chief judge a brief, whatever you feel comfortable disclosing in terms of what you want investigated, that might help, but it is not a requirement. That, as I said, the first step is you make your request. When they say no, you offer them some education. Chief judge, really, you can call a grand jury. You don't have to wait for the prosecutor to make this request. If he won't call a grand jury, you go to your lawyer. Okay? I mean, that's
Lots of money?
I'm afraid that's what it's about, you know. But, as I said right up front, the solution is not the grand jury. The solution is what Mr. Krug indicated. We struggle not against flesh and blood, but against principalities and powers in heavenly places. That is where the battle has to start, with prayer. We have to increase evangelism, and we have to have discipleship that's based on biblical teaching in the church of the proper role of government and the proper place of morals in society. That's the beginning. That's going to lead us to people who, when you go to the chief judge and say, Your Honor, here's the Christian history of America, and the grand jury is a part of that, and the grand jury can investigate criminal activity. If there's some report that there is some, I'd like you to call a grand jury and let them investigate this crime. Then that judge should, based on their training by their pastor in church, should say, sure. Okay, now that may sound simplistic, but that is where we need to get to to where we have an understanding, a unified understanding of how the society is supposed to be structured, how the government's supposed to work, the limited role of government, and the proper place for the administration of justice in our society.
Thank you. Let's stand. Now, I would like for you to take as an assignment to go and try to find who the grand jury foreman is in Sarasota County, Charlotte County, and wherever you go back home. I think that would be a good first step for us. And either email me if you're going to be gone next month, or come back next month and tell us what you found. And we'll go from there. I've got a sign-up sheet in the back if you want a copy, or you can go take a DVD of my